Good afternoon. Today is March 14th, and welcome to the Ways and Means Committee bill hearings. First, we will call House Bill 1237 and welcome Delegate Kaufman. And you have two folks that are signed up favorable. Yes, Rachel London and Leslie Margolis.
Thank you, Madam Chair. Can you hear me? It's great to be back home. My first job out of college was working for this committee, so it's great to be back home, and Stan Ward greeted me back then, and thank God he's still here serving you. So I'll always be grateful to Chair Hickson for giving me my first job out of college, but it's good to be home. I want to talk to you about a bill today, but what I'm going to end up doing is, in a lot of ways, rebutting the testimony of Mabe, who, in a great surprise to all of us, I'm sure, is opposing the legislation. But first I want to just say good afternoon, Chair Atterbury, Vice Chair Wilkins, and my esteemed colleagues on the Ways and Means Committee, and I think some folks from my committee, the Judiciary Committee, are here. Thank you for allowing me the opportunity to testify in support of House Bill 1237, the Special Education, Judicial Actions, Attorneys' Fees, and Related Costs. Now, what I wanted to, this is one of the reasons, Madam Chair, that I ran for office, because as as a student, I had many IEP meetings. I had many wonderful teachers, including Sally Merrick, who's in the audience today. But I saw repeatedly that parents were outgunned at IEP meetings. And just like your burden of proof bill, which was very courageous, this is another bill to even the playing field for parents, because Mabe talks about how it's all collaborative. And, you know, in honor of my old boss and it being almost St. Patrick's Day, I'm here to tell you that that's malarkey. Many parents feel outgunned. If it was so collaborative, why would so many parents drain their savings to pay for attorneys and expert witnesses? But the bill would ensure that families can advocate for their children without facing a prohibitive financial burden, because you'll remember from the 2021 hearing, the veterans, that one of the parents testified that it was about $1,500 a day for expert witnesses, and she had to do a bake sale to raise money to pay for the attorney and the expert witnesses. Since the passage of the Individual with Disabilities Education Act, IDEA, schools, as this committee has been very familiar, are required to develop IEPs for most students with disabilities and IFSPs for students 0 to 3. If parents of a child with a disability disagree with the IEP, they can seek resolution through a due process. It's also important to know that school systems can and do take parents to due process themselves. Due process hearings are expensive, costing parents tens of thousands of dollars. HB 1237 will lower the financial burden on families by requiring school systems to pay for the prevailing family's attorneys and witness fees. Now you may say, Aaron, why do we need to pay for attorneys' fees? Because that's included in the IDEA as it is. I just want to codify it in Maryland law. And also expert witness fees are not included. This will drastically lower the cost of the hearings and will allow more families the opportunity to advocate for their child's education. And I just want to say that I'm very disappointed that the Maryland Association for Justice notified me at 4 o'clock yesterday, that they will be opposing this bill because of far-fetched hypotheticals that will, in the end, result in parents continuing to have to drain their savings. They're going to submit testimony, so I'm not going to dignify their hypothetical concern with more of an answer. Mabe claims that the bill would have a significant financial impact on school systems. I don't have any sympathy for that, however, because an investigation conducted by the Baltimore Sun found that from 2014 to 2019, school systems won 85% of special ed cases in Maryland. In fact, in those 5 years, parents only prevailed in 14 special education court cases. And the MABE in their testimony talks about the expense and on, but the facts just, I don't have any sympathy, because the Montgomery County Public School System, which I attended, has a budget of over $3 billion with a B dollars. Baltimore County Public Schools System, the home of our beloved Education Committee Chair, has a budget of $2.5 billion. And in MCPS at least, and I think in Baltimore County too, they have a specific line item in their budget for special education legal expenses. Families for sure don't. While I realize smaller counties have smaller budgets than those of MCPS and BCPS, they are still better positioned to absorb the fees than families. Special education cases have been described as a David versus Goliath issue, where many parents simply do not have the resources required to win, because they're often forced to engage in pro se representation, and they're outmatched by clever public school system attorneys. By granting reimbursement of attorneys' fees and witness fees to families who win their cases, HB 1237 will work to ensure families are able to effectively advocate for their children's special education. And before I conclude, if I may, Madam Chair, I just also want to tackle, in MABE's testimony, they state that we have to comply with IDEA, and that's so expensive. Well, that's a 48-year-old law, and then they mention the Andrew F. case, which is a 6-year-old case. So, so they have had ample time to adjust to these obligations. So with that, I respectfully request a favorable report. You all passed this in 2020, and I hope you will do so again. I'm happy to be the fights for the David and stand up against the lawyers and the MABE, because my parents had to fight so much for me, and fortunately they had the resources to do it, bringing in neuropsychologists and other experts to advocate for me, but I was one of the lucky few. So the process is so unequal. Parents get rolled all the time by school systems. And so my bill that was authored by Delegate Lopez in 2021 will do a little bit to even that playing field. Thank you, Madam Chair. It's good to be home.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. My name is Leslie Seid-Margolis. I am a managing attorney at Disability Rights Maryland. I manage our education and mental health work, and I also chair the Education Advocacy Coalition. I'm glad to be here today in support of House Bill 1237. Parents cannot meaningfully exercise their due process hearing rights. These are rights that are guaranteed to them under federal and state law without access to experts. And we know that school systems have a ready-made pool of experts with their staff. We recently did a due process hearing, Disability Rights Maryland, where every single administrator and service provider was qualified as an expert, down to the social worker who graduated with her degree in 2020. So she doesn't even have 3 years of experience, no conference presentations, no publications, just working in a school for a couple of years. And she was qualified as an expert. So with that, it becomes really impossible for parents to counter that level of people qualified as experts without their own experts. And so many families don't have the resources to be able to pull in even one expert, especially knowing that there's no possibility of recouping those costs if they prevail. So with this bill, there would at least be the possibility of recouping. DC has passed a bill, and back in 2012, Delaware passed a bill allowing recoupment of expert costs. So we ask that Maryland do the same. This really is at the heart of it about access and equity. Thank you.
Madam Chair, Madam Vice Chair, members of the committee, I'm Rachel London, the Executive Director of the Maryland Developmental Disabilities Council. You have our written testimony, and I don't have a lot to add. You've two fantastic witnesses. Just want to reiterate two things. This is another tool. right? We've talked a lot about additional tools for families. I think I have even here in front of you. This is another tool. And while we might be close to a leader, we're clearly not setting, precedent here. You just heard that Delaware, our neighbors, Delaware and DC do in fact already do this. And then the last thing I want to reiterate is Delegate Kaufman mentioned some of the numbers. So in the last 5 years, so 18 through 22 in the last fiscal years, there were only 92 cases. 92, that's it. We are not talking about an exorbitant amount of due process cases, and clearly we're talking about even lesser amount when you're talking about the families being the prevailing parties. So for all those reasons, the council strongly supports this bill, appreciates the sponsor, and I'm happy to answer any questions. Thank you.
Thank you. First, I want to say, for those of you who missed it, we are going to properly welcome Delegate Kaufman because he working for former Chair Hickson was his first job out of college, so welcome back. I want to say I appreciate this bill, Delegate Kaufman, and I'm sure my committee members know based on the session so far, I appreciate this bill. I think it's a great bill, so we're going to take a good look at it. My question is there an issue? My only concern is, can we state what happens in the federal courts? Can we say if somebody's in federal court at the state level, then somebody else has to pay their attorney's fees? That's my only concern.
What I would say is, you're an attorney, Madam Chair, recovering Judiciary Committee member, but I would defer that question to the two lawyers. But I would say that there are numerous other instances of law where the losing party has to pay the person's attorney's fees. But I defer to Rachel and Leslie are both lawyers, so I defer to them.
And I have no problem saying that for a state court. Just going beyond that, I have a little concern, but if you have an answer or response.
Right, so one of the reasons this has come about is that the Supreme Court issued some years ago the decision in the Murphy case where they noted, in a footnote actually, that because the Individuals with Disabilities Education Act did not specifically say that you could recoup expert fees, you couldn't. It didn't say you couldn't get them. It didn't prohibit awarding of fees, but they weren't automatic if you prevailed the way the ability to recoup attorney's fees was. What the IDEA does provide is that states can impose requirements that are higher than or more than what the IDEA imposes. And we have done that in numerous situations, such as our restraint and seclusion requirements, such as requiring transition services to begin at age 14 rather than 16, which is what the federal law requires. So there are instances where Maryland imposes additional or higher level requirements than what's in federal law. And this would be another instance of that. Delaware's law specifically does permit recovery of attorney's fees for both state court and federal court proceedings if parents prevail.
Are there any other questions? Delegate Hornberger.
Thank you, Delegate, for bringing this bill to our committee. Very important issue. So we've heard this bill in a variety of different ways, and it's my understanding, if you could clarify, there's an initial uptick in the matter of cases that are resolved in the states that have implemented this procedure. But after that initial uptick, over time, they tend to drop off because it forces more of a collaborative approach between the school system and the parents. Is that what you've seen, or is that just anecdotal?
Well, I haven't seen things about the initial uptick, but what I would say is that I would say it does not, I wouldn't be surprised that it leads to a drop-off, because right now, and excuse my bluntness, but I'm just fired up about this issue right now, in a due process hearing, school systems often clean the clock of parents, or even if they win, the parents are still out thousands and thousands of dollars. So now that now that the school systems, if they lose, will have skin in the game, I imagine,
Right.
they'll push people towards mediation instead.
Yeah, and just to clarify, the uptick would be in reimbursements of the legal fees because
Yes, but again, Delegate, I would say that the reimbursements could easily be absorbed in a $3.15 billion budget in my county, or $2.5 billion in Delegate Ebersol's county. And also, frankly, unless, God willing, the chair's burden of proof bill passes, I expect a continued trend of, in a 5-year period, parents winning only 14 cases. So this is only going to happen once in a blue moon that parents win. Yeah, and Leslie has a point.
So right now, under federal law, parents who prevail can recoup their attorney's fees. That's already federal law. The reason this is coming as it is with attorney's fees and expert costs is that Maryland put the attorney's fees piece in COMAR, in the regulations, but did not actually put it into the statute. So in order to tack the expert costs on, there needed to be the attorney's provision in the actual education code, and that's why the attorney's fees piece is there. But under federal law, parents already can recoup their attorney's fees if they prevail, and that's a big if, as you know from those numbers. So I'm not sure that adding the expert costs to the attorney's fees, if parents prevail, would create that much of a difference in the number of hearings that happen, because the attorney's fees probably represent the bulk of the expenses for families. But those expert costs represent enough of an amount of money for families that they can be a real barrier for families in accessing the ability to go to a hearing, which they can't really even have a shot at winning without an expert.
Okay, thank you for that clarification. Thank you.
And if I could, Madam Chair, just very briefly, I want to take a moment to thank my friends Delegate Vogel and Attar for co-sponsoring the legislation.
Of course. Any further questions for Delegate Kaufman or the witnesses? Okay, seeing none, thank you all very much. Thank you, Delegate Kaufman. And now, Mr. Willems.
Thank you for your patience, Madam Chair. Good to see you, John. We both have bills to pay.
That's right. Thank you, Madam Chair, Madam Vice Chair, members of the committee. John Willems, representing the Maryland Association of Boards of Education. A shout out to my longtime colleague, Leslie Margolis, for being a straight shooter and clarifying that this bill is not about attorney's fees, right? This bill is about expert witness fees. And so attorney's fees are in the title of the bill. It was in the title of the bill in 2020 and 2021, but that's ultimately not what this bill is about. So please consider Maeve's written testimony in raising concerns about authorizing the recoupment of expert witness fees in excess of the requirements under federal law, and for the reasons articulated in Maeve's testimony, which really don't focus as much on cost as my dear friend and sometimes ally and nemesis on this bill pointed out. It's not really about the cost. It's about driving increased litigation and the kind of mill and machine of expert witness fees generating a race to the courthouse in that regard. But again, we feel very confident and positive about the work that we're doing with students receiving special education services. This committee, more than anyone else in Annapolis has heard our concerns about staff shortages, mental health, behavioral health staff, educators, and certainly special educators. And that is troubling and has negatively impacted the special education community in ways through COVID and the pandemic that we could not have foreseen. Learning loss and recovery of that loss has been, I think, exceptionally pronounced, requiring compensatory education services at considerable expense. And so it is a challenge, undoubtedly and admittedly. Will this bill solve problems in a meaningful way or divert resources away from serving students? We feel that it will divert limited resources away from serving students and request an unfavorable report for that reason. Thank you.
Any questions for Mr. Willems? I have a question. We've had multiple bills in this committee that are aimed at helping parents, in particular in this situation when it comes to individuals with special needs, when it comes to just advocating for their children. And each time, Mabe has come in here and testified unfavorably. So my question to you is, and you don't have to answer now if you don't want to, you can go consult with whomever it is you consult with at Mabe, but what is it that you think you all could support in terms of supporting parents who have children with special needs that are going through it financially and emotionally? What could you get behind?
Madam Chair, we have supported with amendments, and we do often begin in a position of opposition to bills that are either unfunded mandates or intrude on local board authority, as this committee well knows, but bills to expand the parental consent provisions or the parental rights to veto decisions of the school systems. That bill passed. We put considerable time and effort into that. We have worked with the advocates on the issues of restraint and seclusion over the years, and the inclusion of those provisions in IEPs or exclusion and prohibitions of those services. And we work with the state board at the regulatory level. Our regulations exceed federal law in many instances, including a couple of which I just described. And so, yes, we are positive and defensive about the good work we feel is being done in school systems. We feel we have very high caliber special education services and a lot of happy customers, if you will, not to detract in any way from the folks who come to Annapolis and articulate their concerns about needed improvements in those services.
Well, I don't think that the efforts put forth this session on behalf of parents and families has any way diminished the wonderful work of special ed teachers in the state of Maryland. And in fact, I don't think anybody on this committee has said one negative thing. And if we, just had a magical pot of money, but, this committee knows we have a serious revenue issue. If we had a magical pot of money, I'm sure this committee would throw it all at, the school system and help all the teachers. But I think, it's unfortunate from my perspective as my second session chairing this committee that Mabe's position continues to be in opposition of supporting parents, because the school system is a community. It's a community of teachers, it's a community of students, and it's a community of parents. And so we all have to move in the same direction for the betterment of everybody in that community. So I look forward to the day, sir, when you can come in here with a supportive position while I'm chair from Mabe. Thank you.
Thank you.
That concludes the testimony on House Bill. Oh, I'm sorry. Delegate Pastor has a question. Mr. Willems.
Good afternoon, Mr. Willems. It's good to see you again.
Good afternoon, Delegate Pastor.
And seeing you again, I know the kind of work that you do, and I know all of the things for which you stand, but I also know that you are speaking for, as well, a large number of people out there who are representing, and I'm thinking of the legislative committee now. I know that well. And so I know you're speaking for representatives from all of the LEAs. So with that being said, we know that that financial piece falls back, the fiscal piece falls back on the LEAs. So I want to start with this question. how do you define an expert? Because I heard the attorney early on who gave just a plethora of folks who have been called experts. I'd like to know how you define an expert.
So, Delegate, it's an excellent question. So there are experts in assessing students' cognitive abilities and how those cognitive functions affect the student's ability to learn. And there can be certainly a blend of physical and cognitive abilities and disabilities that impact students. And so there are many private providers, clinicians, psychiatrists, and other clinical specialists, behavioral specialists, clinical social workers. A range of professionals can qualify as experts in their respective fields as it relates to a provision of the IEP that a parent feels is not included or not adequately represented, or essentially being denied as requiring inclusion in the IEP by the school system. And so there is a process where the school system does its professional educational evaluation. The parents can contest the efficacy of that and seek the school system's reimbursement for an independent expert evaluation. When you're in litigation, it can be a little different. There are experts certified as experts in the judicial process, but they have the same backgrounds and qualifications as I described.
So you've really addressed some very specific issues when we're talking about disabilities. Would you agree that students who get to that hearing point probably have more than one disability or the need for more than one expert?
So, yes, the multiply impacted student by a blend or a matrix of cognitive and physical disabilities is quite common.
Thank you. So what Mr. Kaufman asserted in terms of the number of people who tend to lose when we go to hearings or when they go to hearings does indicate that either they don't have the necessary experts, or maybe they don't have any experts, and certainly we would agree that the attorney is generally not enough. Would you agree with that?
Yes.
Yes, because they get to the hearing after having gone through all of the steps, as you pointed out, on a school level. Is that correct? Or?
Yes. Yes.
I knew that was correct because I've been a principal, and I know that. So they have gone through any number of steps with the system to try to give all of those academic and special accoutrements that are needed to move a child. So a parent can tell, would you say that a parent can tell when the child is not progressing, the student is not progressing?
Certainly. I mean, the utmost respect for the parent's determination of their sense of whether the student is making adequate progress. The more recent updated federal standard is to have ambitious goals included in the IEP. And so that is often where the rubber hits the road in terms of the school system saying there is educational benefit to the service we're providing, which is the standard that's required under federal law, and so much more that the parents expect to be accomplished on behalf of their children, and that they want to see reflected in the IEP, and they want to see reflected in the outcomes for their child.
So you know that because you asserted this, that many of the schools, I'm going to just step out and say most of our schools now around the state are understaffed, and even if they have an excellent special educator, they might not have that second person to offer supports. So I'm just processing that for all of the money that goes into LEAs and come that will go into school systems, why do you think that having the necessary people when it goes to a hearing is going to, at the end of the day, offer more of a need for support, fiscal I'm talking now, than if we filled those vacancies? Did that question make sense? Because it almost didn't make sense to me, but maybe it made sense to you.
Right, well, in context of a bill that I'm going to be testifying in support of momentarily in this committee to establish a work group for living wages for non-certificated support staff, including our paraeducators, including our ESPs working in classrooms, that is where we would like the funding to be invested in people on the ground, in the classroom, serving students. We have a shortage of the paraeducators. That means we have a shortage of special education qualified paraeducators that is more pronounced than the general shortage. And so we do have needs to invest in people first and litigation second.
So I guess I'm asking you how we fight against having and paying for experts when we know that for real what happens in our schools are not all that we would like to have happen, and that our students, our children, deserve the opportunity to grow on some level, whether it's the parents' expectation or not. So help me to understand, and I really am done because I know okay, I'm almost done. Help me understand how we have this argument about paying for the expert witnesses, and why we and throw in that why you think, or Mabe thinks, that it then means that parents are just going to come out of the woodwork looking for people, and it will exacerbate the situation. I can't. I read your statement. I read someone else's, and I read a third one that was on a research paper or something. And this is not about feeling sorry for people. This is about doing what is right and what is the law. So help me understand the argument on any level.
It is basically one of inputs and outputs. If you create a new input, which is the promise of recouping fees for expert witnesses, that will generate more litigation involving more experts in a manner that is not recognized as recommended by or called for or required by federal law, and for, I think, some of the reasons included in Mabe's testimony, and that we would just urge that Maryland not adopt a state standard that is in excess of the federal standard in the direction of requiring the reimbursement of expert witness fees in addition to the attorney's fees that are already fully compensable.
Well, as I slide away, I'll just say that what I heard before in reference to what you're just saying shows that the number of people who actually go to hearings is really very small relative to the number of children who are getting these services. Correct. So the likelihood, as I continue to slide away, that people are just going to come out of the woodwork because this bill is passed.
Okay, seeing no, Delegate Miracle North.
Thank you, Madam Chair. So I'm a little disturbed by the rising litigation comment. You made that twice. The people that I'm talking to on the street in the schools don't have the time to litigate, even if this passes. So talk to me about what our colleague Delegate Kaufman said about the privilege that he had with his parents to spend the time and resources to fight when, if this bill passes, we're really helping the ones that cannot. The DC and Delaware have similar laws. If you have the information, that's great if you have it today. We'd love to have it if you don't later on. How are those two states increasing in litigation with the existence of their laws? Do you have the information?
No, Delegate, I do
Okay,
not.
thank you.
Are there any further questions? Okay, seeing none, that concludes the testimony on House Bill 1237. Calling Delegate Kerr, House Bill 12, I'm sorry, yeah, that was 1237. This is 1277. Thank you, Delegate Kaufman.
Good afternoon, Madam Chair, Madam Vice Chair, and my friends on Ways and Means. I'm Delegate Ken Kerr, presenting House Bill 1277, Frederick County Electronic Tip Jar Machines Authorization and Regulation. I appear before you today on behalf of the Frederick County Delegation Chairman Jesse Pippy and the Frederick County Delegation who are in support of this bill. Tip jar games have long been in Frederick County as an activity in fraternal, veterans, charitable and volunteer fire and rescue, ambulance companies, and their auxiliary organizations as a means to support their operations and fund their philanthropic activities and community programs. It is regulated and licensed locally by the Frederick County Gaming Commission. This Frederick County delegation local legislation only for Frederick County makes a single change to the gaming activity by allowing the dispensing of tip jar tickets electronically. This bill does not expand the entities that are currently eligible for local licenses to play tip jars. The bill comes about as a request from fraternal, veterans, charitable clubs, and organizations to reduce the hand-to-hand contact that became a problem during the recent pandemic, and also as a result of the problem with getting adequate staffing, adequate bar staffing that to both handle the bar and have the transaction of the tickets. So I'm submitting amendments to HB 1277 to correct the unintended drafting of this bill that erroneously referred to the Maryland Lottery Commission. This activity is intended to be regulated by the Frederick County Gaming Commission, as is currently the case with tip jars. The amendments delete state lottery and gaming control, which was never intended to be in this bill, and places it under Frederick County's current local law concerning tip jars. So I ask the House Ways and Means Committee to please adopt these amendments and to go on to give this a favorable report for Frederick County Delegation Bill HB 1277. Thank you for your time and consideration.
Thank you. Are there any questions for Delegate Kerr? Delegate Ebersol.
Thank you, Madam Chair. So are we going to have more tip jar establishments in Frederick County if we pass this bill?
First, Delegate Ebersol, let me say I appreciate your question, as this is International Ask a Question Day.
Okay, well then, let me ask another question. Is that question okay?
Yes,
How's
that question's
okay?
good. It's very
Thanks.
appropriate. This does not expand the eligible organizations that are able to have tip jars.
Could it potentially do that?
No, not this piece of legislation.
Okay, thank you.
Any other questions? Okay, seeing none, thank you.
Thanks very much.
That concludes the testimony on House Bill 1277, House Bill 1267. Delegate Wilkins.
Greetings, Madam Chair. Hello, members of the committee. Great to be before you to present my final bill, which is HB 1267. And for the record, I am Delegate Janelle Wilkins. Colleagues, there is a list that many of us hope and really work to ensure that the schools in our communities are not on. And that is the list of low-performing schools. And this list is not a scarlet letter, but it really helps us to get a sense of the schools that really need extra support, extra services, who need wraparound attention, and we really want to ensure that schools do not continue on this list, but that they are turned around, and that's what this bill is about. HB 1267 creates a program to turn these schools around in 3 years by identifying 10 low-performing schools each year and putting them in the Promise Schools program that this bill creates.
What this does is it creates a clear plan for turnaround. And this 3-year plan is steeped in what we know as the best practices for turning a school around. Each school that would be selected for as a promise school would have elements that include the extension of the school year, detailed models of the programming activities that will accelerate student learning. It would include high quality tutors, school professional development, free breakfast and lunch, wraparound services, and also salary increases of at least $7,000 for highly accomplished educators, since we know that new teachers tend to be concentrated in these schools that have challenges. The plan for the Promise School turnaround would have to be approved by MSDE, and the state superintendent would hire a director of Promise Schools and have a budget to make sure that we enhance funding to be able to actually get the job done. The Promise Schools program would also include heavy parent engagement, where we periodically assess and share student progress and accomplishments with the community and with the parents. And the bill also includes what happens if a school doesn't turn around within the 3 years, which currently the bill would allow those students to be transferred out of the school. We are confident that using these best practices for turnaround and really creating a program that focuses in on these schools would help us to ensure that the schools identified would be able to see improvement in their achievements. I will mention, colleagues, that we are working with MSCA to fine-tune the bill. There are a few provisions that we are working on together to figure out quickly, so there may be a couple of amendments on that, and we hope to get on the same page. But with that, I request a favorable report on HB 1267.
Good afternoon, Chair and members of the subcommittee. For the record, I am Mohammed Chaudhry, State Superintendent of Schools, here today to urge a favorable report on House Bill 1267. Delegate Wilkins did a masterful job explaining what's in the bill. We know what works in school transformation. We do. And part of my job is to make sure that schools that are low performing, that keep appearing on the list over and over again, right, get what they deserve in terms of transformation, right? They need the best teachers, they need the best wraparound services, they need the very best. That's not happening all the time, right? And part of this bill is about strengthening that partnership with the department to make sure it consistently happens in the schools where we have to make sure that the very best practices is happening each and every day. I look forward to hopefully being able to see a bill like this happen. If not this session, I will keep bringing it back, because it is happening across the country where students are thriving when it is done with fidelity. This bill is about making sure that our low-performing schools never make it to that list again, and the staff there are supported. And making sure there's some teeth there as well, that the department has the healthy pressure, both with our local LEAs, to be able to transform these schools. The blueprint means nothing if none of these schools come off that list. It truly does not. And we have to make sure that that money lands where it needs to land for these children. So I urge you strongly to have a favorable report for this bill and give me the right tools so I can do my job, which is make sure that there's not a single low-performing school in one of the most affluent states in the country. And so I urge you again to do a favorable report for House Bill 1267. I went a little off script today, but I think this is where I live most days, and so I'll stop my testimony here. Thank you.
And Madam Vice Chair, I'm going to call on Shamoya Gardner to testify virtually.
Good afternoon, Madam Chair, Madam Vice Chair, and members of the Ways and Means Committee. I am Shamoya Gardner, Executive Director of Strong Schools Maryland, here in support of the bill with amendments. So in short, we know that community schools are an amazing, efficacious strategy. But like many other aspects of the blueprint, if community schools are to be successful in the state of Maryland, they must be implemented with fidelity. And so we are also asking the body to support language that is an amendment to the legislation that would ensure that those best practices are codified in state law. We have seen legislation introduced to this point before. Thank you, Delegate Ebersol, for your great work there in 2019. And it is still necessary to ensure that community schools have things like school family councils that are actively seeking the input of parents and the students and educators who are actually served in that school community. We cannot expect the academic, socio-emotional, and community level benefits that community schools can provide if we do not ensure that they are actually being implemented as intended. It is not just wraparound supports, it is a shift in how we lead. It is a shift in how we hold our schools accountable, and it is a paradigm shift for education invested folks all over the state of Maryland. And so we'll keep the testimony very short. You have our written comment, but encourage you all to do please support implementation with best practices and accountability as outlined by the legislation. Thank you.
Thank you. Are there any questions from the committee? Delegate Buckle?
Thank you, Madam Chair. I really, I appreciate this bill, and I appreciate the ideas behind it. I identify with what both my friend Delegate Wilkins and the superintendent said, that everybody wants the same result. We want to pull schools up that are consistently underperforming because it is just horribly unfair to children trapped and to families trapped there. Everybody has slightly different ideas. We have some ideas about boost and other things, and this is a good idea, though. This is a good idea to do it. And so I just had a couple of technical questions or things I saw in the fiscal note. My understanding, at least it says in here, that a child may attend a school anywhere in the state if the promised school in the child's county has not improved student outcomes. So I assume that means after you get the 3-year period where you're getting the increased funding, the increased services, if the outcomes have not improved, then that child can go to another public school anywhere else in the state. How are we measuring the outcome improvement? Is it an objective test? Is it a slate of tests, or what's the formula?
So Delegate, so I just want to back it up a little bit. I think part of the challenge when it comes to school turnaround, especially with programs like this, where you give it all of your best effort, what this bill is saying is that we are going to throw in the kitchen sink. We are going to work with that school, work with that local jurisdiction and that school board, bring in MSDE, ensure that they have the adequate funding. But what happens in those 3 years if all of that doesn't work? Right. We believe that this is going to work, but if all of those best practices don't work. And so one of the tools, as you mentioned, is that if after 3 years that a student would be able to transfer out of the school if this promised school model does not work. And I think your question really deals with how are we measuring that, and the superintendent is going to answer that. But the reason that I wanted to respond and lift that up is that I think one of the biggest question marks is how do we continue to support these schools, and what are the next steps if after 3 years of our best efforts, we're not able to get students to where they are. But I'll turn it over to superintendent.
I appreciate it. I would say that there are a lot of factors that are beyond people's control. So everybody who's an educator, everybody who's an administrator, everybody in this room wants the results to occur. But there are sometimes factors, systemic factors in kids' lives that make it very difficult for them to succeed despite everyone's best effort. That's a tragedy. It's a human tragedy. But it's not something that we can wave a magic wand legislatively and solve sometimes. So I appreciate that. Sometimes there are just schools, unfortunately, no matter what we do, will continue to have some failing metrics, but that would turn it to the superintendent. What are the metrics? How are we going to test that theory?
First of all, they need to come off the list of the low-performing schools list.
Is that the STARS list?
Yes, it's federally required, but I would add an additional threshold to make sure it's not just the bottom 5%, bottom 10%. So they have 3 years to get out. The research is very clear. If you implement strong turnaround strategies, you can get out in 3 years. So if your baseline of, say, English proficiency is 10%, you would set a 3-year target to get out. The first years of turnaround are always about infrastructure building, making sure you get the systems, processes in place. Once you cross that second year, that's when you take off. And so in 3 years, these schools would come out, and so you would go from 5% proficiency, you're now shooting in the 40, 50, 60. You will not make a return to this list. That is the goal of this. We will always have low-performing schools. And if you don't get out, you need some motivation to get out. Sure. And the people have different sticks. The stick here is a parent gets a trigger, an option to be empowered to go to another non-low performing schools. Yes, there are many things out of people's control, but I will tell you, as someone who has only worked in high poverty school systems, there are schools that are thriving and competing with affluent school systems and doing it. It is very possible. I can point to you schools in Texas, in Massachusetts, where they're doing it. They have other challenges, but once they're at your school, you gotta do your part, and this is about doing your part.
And so the only other question, the cost of it, it sounds, I was kind of impressed, I read the fiscal, like it sounds very expensive. It sounds, when you read it, it sounds like, oh my gosh, it's gonna be very expensive. With the blueprint, we're spending billions, it's gonna be very expensive. But the fiscal nut writer, at least, for whatever that's worth, seems to estimate that it would only be about $4 million a year, at least for the first few years, and might grow it up to $12 million, because they're estimating the cost might only be around $400,000 per school. So is that comport with what you think is?
Yeah, to put those elements in, it's about $1,200 per kid. So think of a school that's 300 kids or 400 kids or 500 kids. It depends on the school size. At about $1,200 per kid. If the bill requires me to do 10 schools a year, if they're each about 300-400 students, add around that times 1,200, that's what it would cost permanently to keep that school.
So that's what I'm
in
trying
that
to figure
state.
out, because like the school sizes, and that's my last question, I guess, is
Yeah.
in a lot of these programs that we have done of trying to help schools and to gauge it, we've recognized, not one size fits all necessarily. Urban environments, suburban environments, and rural environments, I happen to think they have a lot in common, but they also have particular challenges. Would you be amenable to, hey, if we're going to do 10 schools, we make sure that we do 1 or 2 of them that are in rural settings, maybe half of them that are in urban settings, make sure that we've got them. So there's a lot of reasons for doing that. Kids are the same everywhere. They learn, they need to have the same background everywhere, but we want to make sure that we're spreading this good program, if it works, equitably across the state.
Absolutely. Delegate Wilkins has told me, I'm going to make sure if this passes, you have to do one in a diverse jurisdiction, because it matters. You cannot just do one, say, in Baltimore City. You have to do one in different places. And so I would be more than amenable if you guys are amenable to that.
Yes, absolutely, Delegate. And we can consider rural and various geographic regions as well. We definitely want to do that.
Thank you for the bill. I appreciate it.
Delegate Ebersol, then Delegate Hornberger.
2 questions, if I may, Madam Chair. First, let's go with the easy one. You say schools of 300 or 400. It sounds like you're focusing on elementary schools. This is a program for high schools also, correct?
Correct.
Okay, so they'd be significantly larger, but that could all roll in.
I've seen a lot of small high schools in Maryland in my visits, but yes, there are some
I never
big
taught
ones.
in one. Let me tell you, they were all 1,600.
Yeah.
Okay, the other thing I have is at the conclusion of a 3-year plan, a student may go to any other state, any other school in the state. Okay, obviously money would have to travel with them. But would it be possible? I mean, I see a scenario where a school empties out entirely, or where it empties out and you're left with half the population that can't find a way to logistically get themselves to another school. Can you talk about that, how that works out in your other experience,
And I'll just start off to say, Delegate, that is one of the pieces that we are working to fine tune. I think, as I mentioned earlier, that one of the challenges is what happens after those 3 years if we're not able to turn that school around. And I think that one of the things I'd like to see in the bill is I think that the students should stay in their county. And we also, if we decide that students would be able to move to different places, we need to make sure that we add various aspects of engagement and support for them to get there, because we know that some parents will have the ability and the wherewithal and the time to be able to transfer their students out if that is an option that we are providing, but some won't. And so we would really need to make sure that we include aspects that help equalize that. So I definitely hear that question and that concern. I don't know if the superintendent.
Let's assume you're going to be successful, but in the event that it doesn't, let's say, hey, it's not going to happen. But if it does, you could have capacity problems also then in some locations for sure. So how's that played out in your
if there's
experience?
capacity, I believe there needs to be some teeth and stick. You can't just throw money and say there's not some motivation, right? There's more severe versions of this, right? Closing a school, etc. I think the promise to parents is we will take this school out of the state it is in 3 years. And if we can't promise you that, if we're not able to do it in 3 years, there's been some amendment ideas thrown out. Can you do an extension for a year or 5 year? I'm open to that if there's adequate progress, but not just automatic. But if the parents, if we can't get it out in 3 years, we need to give parents an option and with transportation. But I will assure you, Delegate, at the end of the day, that school's going to come out. If I put my mind to it and I'm going to partner with an LEA on that school, if it doesn't come out in 3, then it's going to come out in 4. And if it ain't coming out in 5, then we have no idea what we're doing.
But logistically, if you lose half of your school's population
Yeah.
in a high school,
Yeah.
your course offerings and your ability to offer courses decreases significantly, which dooms the school to more difficulties in that case if they can't offer, AP Calculus BC because they don't have enough students anymore.
We're not even offering these kids at Calculus BC right now while
I'm
they're
thinking
full.
optimistically too, Mr.
Have you seen a
Superintendent.
segregated school in Maryland? They're not getting what they deserve.
But we want them to, even the ones who stay behind,
Yeah.
right?
But I hear you loud and clear. I am open. I just would ask for what is the alternative to having some skin in the game when it comes to motivation and a stick.
And
There
ultimately,
has
I
to be
like
something.
this. I'd like to talk. I'd love to participate in a little bit if I could.
Thank you.
Yeah.
Thank you, Madam Chair. I haven't been on this committee for a number of years, talked about this issue. How does because we also created a pathway for community schools, so can you talk a little bit about, does this include a community school? Is there a lane to go to community school and then to this? Because I think there's some overlap between both of those programs. Ours is a little bit more robust, but, we were, as a committee, we're lucky enough to visit a community school in Baltimore City, Wolf School, doing very well, despite all the challenges that they had. So if you could just kind of bind those together.
Yeah. The vast majority of these are community schools already. It's just not working. Community schools in and of itself is not enough to transform the academic outcomes. Community schools takes care of the mental health, behavioral, wraparound needs, and make sure a kid is fed and not hungry when they come to school. But the community schools does not solve the academic deficiencies and challenges, and a community school does not allow you to anchor the best teachers and principals there because it's not the same assignment. That's the X factor of this bill.
Gotcha, okay, so like 2.0. Okay, thank you. Appreciate that.
Any further questions from the committee? Okay, seeing none, thank you. That concludes the testimony on House Bill 1267. House Bill 1288, Delegate Charles. And you have Carrie Watson, Michael Williams, Grayson Wiggins, Adrian Muldrow is favorable with amendments. Okay, well, there's a couple favorable with amendments, so we'll hold off on those. Carrie Watson, Michael Williams, and Grayson Wiggins. Oh, yeah, come on up, Madam State's Attorney.
Thank you, Madam Chair. For the committee, for the record, I am Delegate Nick Charles, and I'm here for a favorable report for House Bill 1288. Good afternoon, Madam Chair, Madam Vice Chair, to my colleagues of the House Ways and Means Committee. This is a good bill that just came to me. It kind of fell into my lap from MGM, and I'm happy for what they've provided. It's about second chances. And this is what this bill is all about, giving folks the opportunity who have done what they need to do, get the opportunity to work within the casino system without any prejudice. And so today I have a really good panel. I have Carrie Watson next to me from MGM Resorts, which is the #1 producing casino in the nation, not just the state of Maryland, but in the nation. I have our state's attorney, and she'll be bringing some good words in terms of the second chances as well. I also have Mike Williams, who is a returning citizen, with part of the Returning Citizens organization. There we go. And so, we offered to have the problem-solving courts here as well, but they were not able to be here. But I want to give everyone an opportunity to hear from this esteemed panel to address those issues and why this bill is so important to help folks in the state of Maryland get that second chance we all know they deserve. And I'll start with Carrie, Madam State's Attorney. Always want to sort that.
Well, thank you so much, and good afternoon, and thank you so much, Delegate, for introducing this bill, and good afternoon, Madam Chair, Madam Vice Chair, and esteemed members of the House Ways and Means Committee. It's a pleasure to be before you today in support of House Bill 1288. This bill really is not only about second chances. This bill, I think, truly is the brainchild of one of our corporate citizens in Prince George's County, MGM. And it is very rare that we have businesses willing to step up and fix what we think is a broken system that continuously holds people not only responsible, but also prevents them from being able to access meaningful employment in our communities. So for a company to say, I want to be a part of the solution, I say thank you to MGM and all of the companies that are willing to provide second chances. This bill is important because currently there are barriers for individuals who have certain certain criminal records from being able to get a gaming license to be employed at the casinos across our state. And so this bill provides that essentially if someone goes through a problem-solving court, and I can tell you our problem-solving courts are very, very tough to complete. So if an individual completes problem-solving court, that means that they really want to turn their life around. So now that they've turned their life around and they want to be employed, and we have employers who are willing to hire them, to have these barriers that we have established in state law prevent them from being able to be employed at that establishment, seems to be a contradiction of where we know the state is headed in terms of second chances. So we ask for those reasons and so many more that you pass House Bill 1288, and I'm happy to answer any questions you might have. Thank you.
Thank you. Good afternoon, Madam Chair, members of the committee. I am extremely happy to be in front of you today in support of House Bill 1288 in kind of three roles. One, as Regional Vice President for Government Affairs for MGM Resorts. Secondly, as the immediate past President of Employ Prince George's. And third, as the President of the Problem-Solving Courts for Prince George's County. That's because HB 1288 is really an equity bill, it's a second chance bill, and it is a jobs bill. As Regional Vice President of MGM, we know that we have a role, we have a goal, wherever we are in the country, wherever we plant our flag, we have a responsibility to really be a part of building that community. Since MGM National Harbor opened 6 years ago, we do know that 331 individuals have gotten through our process and applied for licensure through the MLGCA, but failed. And we don't necessarily know why, but we can make an assumption that in part, it might be because of the statute that currently exists that prohibits some individuals from getting licensed. Secondly, part of that charge is to provide good paying jobs in those communities with great benefits, and we know we do a really good job of that. As immediate past chair of Employ Prince George's, I know that the best way to provide people opportunities and to help them to be motivated to be a really beneficial part of our community is to give them a career with a future. And third, as the president of the Problem-Solving Courts Foundation, I know that this very intense and caring program will get people going in the right direction so they can, again, be part of our community. At a time in this state where we are evolving and we're learning that addiction is a medical condition, this is a continued understanding that that medical condition should not stop someone from having a great future. And with that, I ask for a favorable report. Thank you.
All right, Mr. Williams. Thank you, and thank you everyone for allowing me the opportunity to testify here this afternoon. My name is Michael Williams, and I am the Director for the Returning Citizens Affairs Division for Prince George's County. Our County Executive, Austin Brooks, established our division in May of 2022, and our goal is to coordinate the delivery of services to men and women who are returning to our community from state, local, and federal correction facilities. for periods of incarceration. Our division has been tasked with creating an ecosystem within the county that develops and supports services and service providers that assist our returning citizens in reacclimating back into the community. These services include, but are certainly not limited to, vocational and educational training, securing decent and affordable housing, as well as securing employment. And so we are here today to support House Bill 1288. According to the Maryland Lottery and Gaming Control Agency, more than 7,000 Marylanders are employed by the state's casinos. Moreover, revenue generated from the state's lottery and gaming industry supports education, public health, and environmental programs. By removing this needless barrier to licensure, HB 1288 ensures that more returning citizens have opportunities to secure employment within the state's fast-growing gaming industry. The Returning Citizens Affairs Division is working alongside other public and private Prince George's County organizations to support and enhance resources for returning citizens. And as a result, we enthusiastically support the expansion of career opportunities through this bill for returning citizens. Thank you so much.
Thank you. Before we have questions, there is one more favorable. I just asked Grayson if you could just pop up. Sir, if you could just move to the end so he's in front of the mic, or
Just
okay?
us two, Madam Chair, us two.
Okay, so now we'll do questions for this panel. I'll start with Delegate Patterson.
Thank you very much, Madam Chair, and thank you very much, Delegate Charles, for bringing this very important bill to our attention. It's great. I like the word opportunity, but I need to have some clarity or explanation, possibly from the state's attorney will help us out. In the fiscal report, they define that there is no clear definition in Maryland law for moral turpitude. And to make sure this is solid, are you also requesting that when we have this bill discussed further, that a definition will be included?
Well, I think that one of the things that we need to focus on a lot in this bill is the fact that any crime that is committed, or let's say a person is convicted of, that has to be that individual would have to go through what is called our problem-solving courts.
Okay.
And so that is really a fail-safe, because that requires them to go through a very intensive, some are months long, some are years long, treatment programs within our courts. And when they graduate from those programs, they are really well positioned to be very successful, because these are strenuous, difficult programs to meet the requirements for.
If I could add just briefly, and I had a discussion just before the hearing with the Maryland Lottery and Gaming Control Agency about this moral turpitude issue. Moral turpitude is very broad. I don't know if there's any attorneys in the room, other than the state's attorney, of course. But it is very broad, and I know the agency has a list. I want to say it's like 5 to 10 pages long that really addresses all the items that moral turpitude, but the state's attorney said it accurately. The key issue here is if you graduate from one of these problem-solving courts with a nonviolent drug offense, well, it is an offense associated with drug abuse, and it is a misdemeanor, you could now be eligible to come and work in the casino. And that's the really exciting part of this opportunity.
Thank you very much, because that clarifies a question that I had offered before, and I appreciate the response by knowing it is very definitive. Thank you again.
Delegate Buckle.
Thank you, Madam Chair. And I just wanted to clarify that, because I think this is probably a really good idea. We'll just narrow it down. So the crime of moral turpitude stuff confuses people, because it's a legal term of art that really makes you think, what are we talking about? Are we talking about people who've committed sex offenses or things of that nature? My understanding is it really apply to this. People that have prior gambling offenses still going to be excluded, correct? Yes. Even though they're nonviolent, because they are prior offenses of the gambling code and you were in the gambling business, they would still be excluded from coming in. I get that. Would it only apply then? I think it expressly only applies to nonviolent prior convictions. So even assault in the second degree, those kind of things, those people would be, if they were convicted of that, not charged, but if they were convicted, they wouldn't be eligible. Is that everybody's understanding?
Yeah, as a matter of fact, I know the lottery is going to be offering a couple amendments that we deem as friendly. I think the sponsor deems as friendly as well, that will specify that these are nonviolent offenses, misdemeanor offenses, you know, and again, that you have to graduate from a drug court.
And that,
I'm
and that
sorry,
was my
problem-solving
final,
court.
my final question is that in my experience at least, and I practice a lot of law, I don't practice in that particular field, but we have a former colleague here who's the judge in Delegate Grossman's jurisdiction, the administrative judge who helps to run their drug court. And I, from being very close with him, know it has a tremendous track record of success. There's nothing is foolproof. But so these individuals, they have to be nonviolent, non-felons, non-gambling, and they have to have gone through the problem-solving court, whether it's a drug court. Very few places have it references a DUI court. There aren't a lot of places that have that. But they have to have gone through this program and successfully completed it. And basically, you know, they almost get, in many places, like a little diploma almost, a
That's
certificate
exactly
that
right.
says you
There's a
completed.
graduation.
So they go through all of these things, and part of the carrot of the program is you go through, you do all this stuff, you've completed it, we can get you a good job at probably your county's largest or second largest employer.
That's right.
Thank you, I appreciate it.
Delegate Plavkovich-Carr.
Thank you, Madam Chair. Related questions actually to my colleagues, but let me just clarify, actually, I was a little confused by an issue that Delegate Buckle just raised. The bill does include crimes involving gambling, so someone who has a prior gambling conviction is subject
I
to the bill.
believe, and we could make that correction if necessary, of course, in a subsequent amendment, but I believe that historically, individuals who have been charged with a gambling offense have not gone through a problem-solving court per se.
Okay.
Generally, you could have a theft charge, but as long as it's associated with a drug abuse issue, that's how you could get into a problem-solving court, and then, of course, graduate, and then get an opportunity at the casinos.
Okay, so it sounds like then the intention is that if that provision is in, if it's my misread or maybe not, that would be coming out. So I think that negates my other questions then. Thank you.
Any other questions for this panel? Okay, seeing none, thank you.
Thank you.
Next, Sean Ford, Gordon Mendencia, Medenica.
Madam Chair, members of the committee, thank you for the opportunity to testify. Sean Ford with the Maryland Lottery and Gaming Control Agency. As the previous panel mentioned, we are supporting this bill with amendment. I believe some of the amendments were already discussed, but I just wanted to clarify them. So on page 3, line 3, after nonviolent, insert the word misdemeanor. And on page 3 in line 2, after conviction, insert active parole probation or. Those are our two amendments, and with those amendments, we're very happy to support this bill. Happy to answer questions.
Hi, James Butler, Assistant Deputy Director, Chief of Staff of the Maryland Lottery. I'm just here to answer any questions that the committee members may have. Diversion courts, or what we call problem-solving courts, they're not going to handle felony types of matters. So rape, murder, they would not appear before one of those courts. And again, the amendment that was offered by the agency was to insert the word nonviolent misdemeanor offense.
Okay, any questions? Delegate Ebersol.
Answered. I was going to ask them what their amendment changed in the bill. So.
Any other questions? Okay, seeing none, thank you very much. And that concludes the testimony on House Bill 1288, the last bill of the day. Delegate Wells, House Bill 1234, and you can bring up whomever you'd like, because you got a bunch of folks listed, and then you have 2 virtual. You have, well, I see Ms. Boost, Pia Morrison, Cindy Smalls, Keisha Goodwin, Sally Murick.
Pia Morrison.
And we have appropriations here joining us to hear this bill. Delegate Forbes and Delegate Maggioni, welcome. Whenever you're ready,
All
Delegate
right.
Wells.
Thank you. For the record, I am Delegate Wells. I'm here to testify on House Bill 1234, which would create a work group to study the wages of education support professionals. Last year, we saw similar legislation that also included a bonus for these professionals. While we were able to pass the bonuses, unfortunately, the work group portion of the legislation was lost in the sine die shuffle, as we are all familiar with. House Bill 1234 continues the efforts to create a work group to not only study the wages of education support professionals, but also aims to create long-term solutions with stakeholders and advocates on how to address the challenges we are facing. The first challenge being the shortage of these professionals, such as bus drivers, para-educators, and others who work inside of the building who provide valuable resources to the public education experience. The second being, how do we attract and retain these professionals? I am happy to take any questions you may have, but I request a favorable report on House Bill 1234. Thank you.
Good afternoon, Madam Chair, members of the committee. My name is Cheryl Bost. I'm a 4th and 5th grade teacher in Baltimore County, proudly serving as the president for the Maryland State Education Association, representing over 75,000 members statewide and part of our 3 million National Education Association. I want to first thank you for the bonus that was passed last year, as Delegate Wells pointed out. Our education support professionals haven't seen all of that bonus yet, but thanks to Governor Moore and his budget, that should come to fruition by the end of this year and next year for a $1,000 bonus. But we know that doesn't solve the problem that our education support professionals have. They are essential employees and deserve to work one job to make ends meet. So many of our education support professionals work 3, 4, and 5 jobs just to pay the bills. I want you to think about the people who are helping you sit here today. You have people back in your office that are answering constituent calls. You have people that are getting your bills ready. You have custodians who have been cleaning. The room looks awesome. We have security. We have tech people that are keeping your technology running. Those are the essential education support professionals that you need, and we need those in our schools. They are underpaid, undervalued, and undertrained for all of their positions. So we ask for your support for these important employees. And I want to point out, Delegate Ebersol is as a former teacher. He knows that every teacher is told the first 2 people that you get to know and take care of is the front office secretary and the custodian. And we want to make sure we take care of those essential employees. So we ask for a favorable report so that we can put this commission together and study all of the needs of our education support professionals. Thank you.
Good afternoon. My name is Pia. Good afternoon, Chairwoman Atterbury, Vice Chair Wilkins, and members of the House Ways and Means Committee. My name is Pia Morris, and I'm president of SEIU Local 500. Local 500 represents approximately 20,000 working people across our region, including 9,000 support staff professionals at Montgomery County Public Schools. I'm proud to stand here alongside Delegate Wells, MSEA, and other organizations in support of House Bill 1234. We represent paraeducators, bus operators, security staff, office staff, building service workers, food service workers, and many more. We want to thank Delegate Wells for being a champion of K through 12. House Bill 1234 forms a work group to study wages for support staff professionals and to make recommendations on how to attract and retain support staff. Support staff are essential to the school day. For far too long, they've not gotten the respect nor the recognition that they so richly deserve. School support staff are the backbone of the safe, healthy, and thriving and supportive learning communities that both educators and students need in order to succeed. Education support staff professionals deserve fair wages and recognition for the value they bring to education. During the pandemic, MCPS support staff professional, food, nutrition services, and security served millions of meals to needy families and students each day. Our instructional technology support staff, including media assistants, work to support the delivery and repair of Chromebooks and hotspots for students and teachers. Building service workers performed additional sanitizing procedures, and maintenance workers worked to be sure that the air quality and that air purifiers were put in schools where needed. Our warehouse workers received, sorted, and delivered PPE, home testing kits, and sanitizing. Secretaries pivoted to perform their duties digitally, and paraeducators also learned the new instructional technologies to best support teachers and students during online learning. We're asking that you all provide a favorable support to HB 1234 and ask that you vote yes. Thank you so much.
Good afternoon, Ways and Means Committee. My name is Keisha Goodwin. I'm a paraeducator of 18 years for Baltimore City Public Schools on external assignment as part of the Baltimore Teachers Union Paraprofessional and School-Related Personnel Member Engagement Team. Today, I'm testifying to provide an insight on the hardship I face due to inadequate wages I receive for my skills and hard work. I was compelled to participate in this hearing because I want everyone that has a vote to understand why this bill is necessary. I am not one of exception, but unlike many of my colleagues, I have done the right things, graduated from high school, obtained an undergraduate degree, and even went to grad school, which I completed. Next, I decided to work for a system that prepared me to have the education that would allow me to earn a living wage, the public school system. Unfortunately, public school systems in Maryland do not pay their educational support professionals a living wage. As a PSRP, I worked a full school day and after-school program and had a side hustle to make ends meet. This leaves me with little to no energy or time to fully participate in family, friends, and community functions. I desire to travel to contribute to financial and family, friends, weddings, and other things, to donate to my community, and even donate to political campaigns, but I cannot. I have a child in college. I need my son to be able to only focus on his academics, extracurricular activities, volunteering, networking, internships while in college, but he cannot. Instead, he has to worry about whether he should work a part-time job because I cannot afford to fully support his college education. Is it fair that he has to have a school loan, bill balance, and still worry about taking on part-time work because my career as a PSRP doesn't afford me a basic living wage? After 18 years, I still have a passion for working with children, yet this passion and the high demand of this professional field still leaves me living in a mixed to low socioeconomic status community. Am I not worthy of the American dream? I'm asking you to vote in favor of HB 1234 and the solutions that it comes up with. Thank you for bringing this bill to the committee floor.
Good afternoon, committee members, and thank you for this opportunity to share my strong support for House Bill 1234. My name is Sally Murick. I'm a paraeducator and the coordinator of the paraeducator program with Montgomery County Public Schools, where I have worked to support staff and instruction of students for 32 years, including Delegate Aaron Kaufman, who was here earlier, I had in 7th grade. I want to say a special thank you to Delegate Wells for her leadership on this important issue. Educational support professionals, specifically paraeducators, were left out of the blueprint for Maryland's future for them to be recognized and respected as the integral partners in student instruction and learning that they are. They were removed in the 11th hour before passage of the bill, and I hope the work group being formed by this legislation will rectify that mistake. They serve as co-educators and are due to the same respect and recognition. Montgomery County Public Schools has approximately 2,700 paraeducators. 60% have a 4-year degree, another 20% have a master's degree, and we have a number that have PhDs. Our paras have chosen this as their career, not because it is all they can do. They love supporting the academics and growth of our students. They are flexible and willing to use their instructional knowledge and skills to quickly support school operations and instructional needs in real time as situations arise. During COVID and continuing through our current school year, many paras have stepped in to be teachers covering classes for a day, a week, and even as long-term subs because of high staff absenteeism and unfilled positions. Paras build relationships to develop and promote the whole child. Paraeducators love working in schools and supporting the academic and well-being development of our students, but they have financial needs and families too. Low wages are affecting our recruitment and retention of these valuable and educated employees. Many must work second jobs and struggle to provide for their families, buy homes, and provide for their futures. We have heard terrible stories of paras being homeless and living out of their cars, even though they are fully employed by our schools. Many cannot afford to live in the county where they work. More than half of all support staff working full-time in 2021-22 earned less than $35,000. 70% were paid less than $45,000. They are essential but are not paid as if they are. Paras, our educational support professionals, are the backbone of our schools. They deserve a fair wage and recognition. We ask for your support to pass this bill. Thank you.
Thank you. There are more folks, committee, but is there any questions for this first panel? Delegate Patterson.
Thank you very much, Madam Chair, and thank you, Delegate Wells, for bringing this very important bill to our attention. And for full disclosure, I was a teacher at one time as well, and on Charles County Board of Ed for 12 years. I really like the bill, and I have one question as relates to the overall focus. And I'm surmising your answer is going to be yes. Within the bill, it seems to focus on wages, but also is there a focus on educational advancements or career ladders for paraprofessionals or educational support paraprofessionals? That wasn't a trick question. It was just you know, because I am very big on career ladders and knowing that there should be greater compensation with that. And I also noted that some of the presenters indicated advanced degrees. So within your bill, will there also be, in your work group, a focus on career ladders as well?
Yes, and thank you for your service as a teacher. I'll be sure to note that the next time. I'm sure you remember it was the secretary and the custodian to be friends with. But yes, we would hope that the committee, the work group, would look at all aspects. We have currently an ESP Bill of Rights that all of our folks are signing on to, and it talks about career advancement, professional development. Often our education support professionals are the last to get professional development or left out of any professional development. And we also support many of the Grow Your Own programs that you've seen, which help people who are already employees not lose salary while they're doing their student teaching and other things so that they can move up. So yes, we would hope the committee would look at a well-rounded group of items, because there's a lot of things that would help our ESP to not only make a living wage, but be successful in their career.
Thank you so much.
Are there any other questions for this panel? Okay, thank you very much. Next, we have Sally Murick, John Willems, and then there are two individuals signed up virtually to testify.
I was just here.
Oh, I'm sorry. I apologize. John Willems, and then we'll go to the two folks that are virtual. While he's coming up, I would like to acknowledge the young ladies from Montgomery County from Community Bridges. Welcome to the Ways and Means Committee. We can applaud them. Whenever you're ready.
Madam Chair, members of the committee, John Willems, representing the Maryland Association of Boards of Education. We were strong supporters of the bill to establish this work group and provide the employee compensation bonuses last year. The bill was stripped of the work group and passed only as the bonus bill, and so strongly support establishing this work group. It beats putting a bill in with a big fiscal note, catching everyone by surprise and giving everyone 15 to 20 days to figure it out and how it's going to be reflected in the budget. This will cost out the living wage issue. I'm certainly not an expert in living wages. I understand that there's a Tier 1 and Tier 2 in the state. The Tier 2 living wage is probably more impacted by the minimum wage hike that is ongoing. But I have to emphasize, greatly respect the work of our non-certificated staff. As has been testified to, they are across the board from computer technicians to custodians to educational support staff in the classroom. The blueprint, we love the blueprint. The blueprint does not include everyone. It doesn't even include all educators, as has been the subject of another bill pending this session. And it's certainly, while it provides some facility maintenance funding, which can help with our maintenance staff, and that's appreciated, it doesn't actually encompass the living wage issue raised by this legislation, and we think it's highly recommended for a work group and an analysis and explanation for the funding and policy issues that this will raise. Thank you.
Are there any questions for Mr. Willems? Okay, seeing none, thank you. That concludes the testimony on House Bill 1234. That concludes the testimony, that concludes the bill hearings of the Ways and Means Committee today. We have some subcommittee announcements, folks. Please pay attention. Education?
Education Subcommittee will meet directly after this meeting. If you want to find a quiet room somewhere or just go sit on a sofa, you don't have to go all the way up to your office if you want to do that. We're probably not allowed to be in the same room, but we can separate ourselves a bit. So,
Early childhood?
Early childhood is meeting immediately after education, so please stay tuned to their live stream. But I'll try to text everyone when we're getting close.
And Madam Vice Chair is not here, but she is meeting after early childhood, so everyone pay attention. So we are going to be voting after all the subcommittees meet. So please just pay attention to your email and to the text message situation that we have, okay? Thank you.